Oh, and we are now live. Hello, everyone. Welcome to Legal Lunch and Learn, a weekly live show where we ask an expert your questions on a legal topic. My name is Cindy. I am a staff attorney here at Maryland Legal Aid. My co-host here is the Director of Community Lawyering Initiative, Attorney Megan McDermott.
Fine, thanks, Tiffany.
Joining us today is our housing expert, Carwolo Kame.
How you guys doing?
Our topic today is tenants facing evictions. Please feel free to put your questions about evictions in the comment section down below, and we will answer them later in the show. If you want to keep your questions anonymous, you can also direct or private message us through Facebook. So before we get started, please remember that if you do have an immediate civil legal issue, you need to contact us. And our email here is lawyers, LAWYER, at mdlab.org. So that's lawyers at mdlab.org. The phone number to contact us is 443-451-2805. And of course, our production engineer, Alec, is working behind the scenes, and she will post those informations in the comment section down below for you as well. And last but not least, just a clarification. Just because we're answering your questions today, it does not establish an attorney-client relationship between any of the attorney that you see here today or Maryland Legal Aid. So again, if you do want to talk one-on-one with an attorney for free, please contact us at the information provided. So with that out of the way, let's talk to our special guest today. So hi, Carolo, how are you doing?
Doing well, Cindy. How you doing today?
So before you came to Maryland Legal Aid, I understand that you did a lot of housing law. Can you tell us what kind of cases that you've worked on before?
Yeah, so prior to coming to Legal Aid, I worked at another nonprofit, and we did mostly housing. And so landlord-tenant issues were one of those cases that we did fairly regularly.
So let's talk about landlord-tenant issues right now. So first, I want to talk about tenant responsibilities because there's a lot of information that's floating about right now that's super confusing. So first and foremost, if I am a tenant, do I have to pay my rent right now?
Yes, absolutely. So you are still responsible to pay your rent, and I strongly urge you to pay if you can afford it.
So what it's such a hard time for everybody right now. So what if I cannot pay my rent? Let's say through, maybe not due to COVID. Maybe I was behind on rent even before COVID started, and now that things have gotten worse, I'm just falling further and further behind. What happens then? Do I still have to pay my rent?
Unfortunately, you still have to pay your rent. So, and this might lead to your follow-up question, but if you cannot pay your rent, so there was an eviction stay that was imposed by the governor, and that stay was lifted on July 25th. So, for those who still cannot afford their rent as a result of a reason pertaining to COVID-19, you can still use that as a defense against eviction. However, if your failure to pay rent has nothing to do with COVID-19, then you may be evicted.
So I'm gonna back you up just a little bit. So when you talk about a stay on eviction, what does that mean?
So basically, on March the 5th of this year, the governor signed a state of emergency, and as part of that state of emergency, he imposed a moratorium, so which is basically a stay. What that meant was that during that period, you could not be evicted or for failure to pay rent. So you could be evicted for other reasons, but as far as failure to pay rent, you could not be evicted or from the beginning of the state of emergency up until July 25th.
So now that it's after July 25th, what if someone could not pay rent due to COVID? For example, if my business went under because of COVID, or my boss told me that they have no work for me because of COVID, um, so if that's one of the reasons, how do I tell the court, what evidence do I need to bring?
So it's not very clear what specific documentations you need. However, you have to show documents that are objectively verifiable. So for instance, a letter from a former employer stating that you've been laid off as a result of COVID-19, or if you have evidence that you couldn't go to work because you were taking care of, a child who had to be home because of COVID-19, or things along those nature. But it's going to be verified by a judge who's going to make a decision whether or not your documents are reasons enough to compel him or her to say that your failure to pay rent is as a result of COVID-19.
Okay, so what if it is determined that, let's see, I couldn't pay rent and the judge agreed that I couldn't pay rent due to COVID, and I do have that defense in court. Am I still liable for anything else? Meaning, like, if I was found that I couldn't pay rent due to COVID, would I still be punished for not paying rent?
No, you will not be evicted, but you will still be ultimately responsible for that rent. So the rent is in forgiven. It just keeps adding on. So eventually you will be responsible to make those payments.
So I
As
would
far as
still,
we know.
so I could still be sued for the back rent, even if I wasn't evicted.
Yes, unless there is some change to the law in the future, you can still be sued or
Oh,
for financial judgment for the back rent.
so let's talk a little more about the eviction procedures right now, because I don't know if everyone understand what legal eviction actually is. So what does a landlord have to do to evict me?
So prior to COVID, basically a landlord gives you notice if you are behind on your rent. They don't really have to, or you will receive that notice from the court that the landlord has filed an action against you or for failure to pay rent. There will be a court date. You can go and raise a defense if you have one, or once, if the judge decides that you do owe rent, or he or she would then issue a warrant of restitution that the landlord takes to the sheriff and schedule an eviction. Now, because of COVID and because of the CARES Act, the landlord has to give you a 30-day notice for failure to pay rent. That's the only thing that changes. So after that, everything else is what it used to be. I understand, and this is something you might want to check with your respective counties, that some sheriff departments may or may not be scheduling evictions now. So it's something you might want to log into specific to your counties.
So am I correct in saying that if that's the case, it sounds like you can only be evicted if a sheriff comes to your door?
Absolutely. You can only be evicted, one, by a court order, and that court order has to be enforced by a sheriff. So now, obviously, if you receive a court order to evict by a certain date, you could on your own leave before that date. But if you are still present in the premises or by the date of the eviction, only a sheriff's officer can evict you.
So just for those who might actually already have what's called a warrant of restitution, my understanding that a warrant restitution is the document that the sheriff will have to evict you. Is that correct?
That is correct.
Okay, so if that has been entered and the sheriff has it, and it is a county that, where sheriffs are still enforcing evictions, does that mean I have to leave the house immediately, or is there maybe a lag period before the sheriff comes for me?
The sheriff is going to give you notice. Will give you some notice, and again, it depends from county to county, or it could be 4 days, 7 days, and there might be one or two counties that don't give notices, but I believe, and I stand corrected, but I believe every one of them give at least a couple of days, if not longer, or notice before you can be evicted.
So I also hear that there might be an executive order from the president about staying in evictions right now. Can you talk to us about that?
Sure. So the executive order does not extend the moratorium. All it does is it directs the CDC to consider whether any measures or temporarily halting residential evictions or for failure to pay rent are reasonably necessary to prevent further spread of COVID-19. It also directs the Secretary of Treasury and the Secretary of Housing and Urban Development to identify any and all available federal funds to provide temporary financial assistance to renters and homeowners who are facing hardship as a result of COVID-19. So basically, it doesn't do anything now. It doesn't prevent evictions now. It just directs the relevant agencies, departments to explore ways to prevent evictions in the future.
So I am hearing from some clients, and from the community that sometimes landlord just tell you to leave, and there's no court date. There's nothing. Can landlords do that?
No. So if a landlord tries to evict you without a court order, or whether it's by shutting down utilities, changing the locks, or going into the house to remove you, or you have a right to be there without a court order, so you should call the police or your local law enforcement agency, and they will prevent them from doing that. You can also give us a call, and we will give you whatever legal options you have available. But just to emphasize, you can only be evicted by a court order.
Just to clarify, before the landlord gets to the court order part, how would I know? How would I know that the landlord wants me gone? Besides, knocking on my door and telling me to leave.
But if there is a court order, you would have received notice even before you receive a court order. So before a court makes a judgment, both parties have to be on notice of it. So you would have had a chance to receive a notice of a hearing in the first place. And even if you didn't attend the hearing, you will, again, like I said, you will receive notice that there is a warrant of restitution.
All right. So another reason a landlord might ask me to leave, especially right now, is that maybe I'm taking in family members who are, who might have nowhere else to go due to COVID. Is that the same as going to court for not paying rent if my landlord wants me to leave for having people who are not on the lease, in my house?
No, that's not the same. So every other aspect of the lease is still enforceable. So if you are creating conditions that are threatening the health and safety of other tenants, or if you are in some other form breaching your lease, or you could still be evicted for them.
All righty. Thank you for that. So that's all the questions I received before today. Now it's time to go to our co-host Megan to ask you some questions that we received while this live was happening. All right, back to you, Megan.
Cindy. Hi, Carwolo.
Hi, Megan. How you doing?
I'm doing well. So one of the questions we had come in, and these are not all necessarily relevant just to during COVID, but this person has a lease and they're about 6 months into a 1-year lease, and they'd like to know if their landlord can raise their rent during this time.
So generally speaking, the landlord Well, it depends on the terms of the lease. So if generally speaking, if the lease has a provision that says it can be raised at any point, or then that you have to look at the lease and see if it has that provision. Now, if it doesn't have that provision that says the lease can be raised at any point, and of course you have a defense to say that the term of the lease is 1 year, and you cannot raise it during the course of the lease. Now, if I don't know if this is if this is a question itself, but if your lease ends during this period and a new lease begins, can it be raised? Now, generally, yes. However, Baltimore City, Howard County, and Salisbury counties have enacted laws that are preventing an increase of rent for existing tenants. So, for instance, Baltimore City COVID-19 Renter Relief Act prohibits rent increases for existing tenants during the state of emergency and for the 90-day period after the emergency is lifted. Howard County passed the Renter Protection and Stability Act, which prohibits an increase of commercial and residential rents during a state of emergency. Also, Salisbury County passed an act on June 1st that prevent increases during a state of emergency. And it also requires landlord to refund any increases that went into effect after the state of emergency was declared on March 5th. Now, other than those three jurisdictions and barring some language in your lease, then yes, the landlord could potentially raise or increase your rent.
Okay, thanks, Carolo. So it sounds like it could be a bit confusing that there's laws that help protect tenants statewide, and also that specific counties and even cities might have their own rules and regulations. Is that true?
That is correct. So you would want to check, with your county, and as Cindy mentioned earlier, if you have specific issues, feel free to reach out to us, and then we can take a closer look at the specific cases and give you a more specific answer.
Okay. So sort of a related question, another client who has a year-long lease and they're sort of in the middle of their lease, they're like 6 months in, and now their landlord has told them they want to sell the house that the tenant is leasing. Is the landlord allowed to sell the house during that lease period?
So so generally, and this is really even prior to COVID, for a landlord to sell the house, the tenant has the option or right of first refusal, so to speak. So basically, if the landlord has received a bona fide request from a potential buyer, or the landlord has to give that tenant notice and say, someone is trying to purchase my property, and the tenant then has a right to refuse to purchase that property on his or her own. Now, I have to say I haven't looked at the changes as far as COVID, what protections COVID has offered, but I can look into that, and maybe we can post a follow-up answer on that, since I don't have the COVID answer for that.
Okay, so someone could definitely have some time, it sounds like. So your landlord can't just come to you today and say, hey, I sold the house, you have to get out today.
No, that cannot happen, even prior to COVID.
Okay, thank you. So Carola, what happens, so these last two questions, the person had a 1-year lease. What happens to the person doesn't have anything in writing? Do they still have a lease? What kind of legal protections does a person have who has moved into an apartment and never signed anything in writing with the landlord, but they're paying them, $500 every month for the apartment?
Okay. So under Maryland law, if the lease is for 1 year or less, it doesn't have to be in writing. Now, obviously, if there's a dispute, the judge has to uh, weigh the credibility of both parties to see, if an oral lease does in fact exist. But just technically speaking, or you do not need a written lease if it's for a term of 1 year or less. Now, the exception to that is if the landlord owns 5 or more rental units in the state, then the lease must be in writing. And if it's not in writing, there's a presumption that it is a 1 year lease unless the tenant decides to end the lease earlier by giving a 1 month written notice.
So in that situation, the tenant has an ability to end the lease early without any penalty?
Without any penalty, as long as they give a 1 month written notice. But that is only with landlords who own 5 or more rental units in the state. But if it's a private landlord, or then if he or she insists that it's a 1 year lease and the tenant says it's a 3 month lease, then that's something that they will have to resolve in court.
Okay. So we've been talking, because of COVID, I think we've talked a lot about why people might be evicted if they can't pay rent. Are there reasons that tenants could be evicted other than failure to pay rent? And does the court process look the same?
Yes, so there are definitely reasons why a tenant could be evicted without, for non-failure to pay rent reasons. Or one of those reasons, as I mentioned earlier, is if you are a threat to the safety of other tenants, or you could be evicted. Now, generally speaking, if it's some other breach of lease, the landlord gives you a notice and say you must vacate within, depending on the counties, it could be 14 days, it could be 30 days. If it's something that is a threat to the life and safety of others, it can be, closer to the 7-day mark than the 30-day mark. And obviously, if you don't leave, then they have to still go to court and get a court order. So even notwithstanding the reason for the eviction, if you might receive notice that you've breached the lease, so you have to leave in 14 days and 30 days. But if for whatever reason you decide not to leave, or the landlord still has to go to court and get a court order to have you evicted.
Okay. And what about, say there's a safety concern in the apartment, so there's the toilet's leaking and it smells and there's water. There's obviously the option of paying into rent escrow, but what happens in the situation where there's a broken item in the apartment, there's a safety concern, but also the tenant isn't able to pay rent right now, maybe because of COVID? Do they have an option? Does the landlord still have to fix the item in their property even though they're not paying rent?
Yeah, so that's a brilliant question. So even if you cannot afford to pay rent as a result of COVID, you still have the right to live in a safe apartment or home. So you can still file for rent escrow. Now, the judge might still require you to pay into escrow since there hasn't been let me drink some water. Since there hasn't been any stay on paying into escrow accounts. However, the judge has a discretion to lower the amount you can pay into escrow and potentially even suspend the amount you can pay into escrow. So it's really a case-by-case basis. So if you are in a property where your health and safety is at stake, and go ahead and file the rent escrow action and explain your circumstances to the judge as to why you aren't able to pay into an escrow account. And it's possible that you wouldn't, at the very least, won't have to pay the entire amount into escrow, and hopefully you wouldn't have to pay anything. But it's really case by case and dependent on the judge.
We had a question come in through the live stream just now, actually, and someone is asking, are there any special laws around eviction or tenants' rights when children are involved, when minor children are living in the property? Does that make any difference for any of these laws?
As far as I know, I don't think there are any laws that are specific to minor children now. However, as I think I mentioned earlier, if you have a minor child who, you have to stay home to take care of because of COVID concerns, and that is the reason why you've lost your income, or then that is a valid defense I believe you can raise, that will fit on the COVID-related reason for failure to pay rent.
Okay, thanks, Carwolo. We have one more question before we bring Cindy back to wrap things up. And you touched a little bit on this already, but once someone is evicted, they've gone through the whole process and they've left the property, they were evicted for failure to pay rent, and let's say they owe $5,000 to the landlord. So once they're evicted, is it over, or do they still have to pay that money back? What happens after the eviction with the money that they owe?
Yeah, unfortunately, it's not over immediately, because what usually would happen is that, if you have security deposit, or the landlord could deduct whatever you owe them from that security deposit. And if you don't have security deposit, or if you still owe more even after the deduction from the security deposit, the landlord has 3 years in which to file for a financial judgment against you. So again, whether or not that happens, it depends on the landlord, but the landlord has that right to sue you for back rent plus attorney's fees.
Okay. And if the landlord doesn't file during that period, then they come back and file 10 years from now?
No. So there's a 3-year statute of limitations on filing for back rent. And if the 3 years has passed, then that case is considered over. So if you are in a situation and it's been 3 years since you moved out and you haven't been served yet, or the landlord hasn't filed the case yet, I should say, then he or she cannot bring it after that.
Okay, great. Thanks, Carwolo. It's been really helpful to clarify. And I think Cindy's going to come back on now and wrap up with you.
Thank you.
Thank you, Megan. So we are now at the end of the show, and for our fellow Marylanders out there, Carwolo, what is the most important thing you would like our audiences to know about tenants facing evictions?
Oh, that's a good question. I would say the most important thing would be to keep up with the changing laws, because there are a lot of, especially now that the state of emergency is still ongoing, there are a lot of people who have been urging government officials, both on the federal and state level, to put in protections for tenants. And even though nothing has happened yet, it is possible that next week or next month, there could be a change in the law that would benefit you or potentially harm you. So it's good to keep up to date with those laws. And we are a free resource. So obviously, if you have any questions about this, feel free to reach out to us. We are constantly researching updates on the law. And like I said, what we've given to you now might change by tomorrow. So it's just keeping up to date with the changing laws would be the most important thing I think tenants can do.
Yep, absolutely. So thank you for joining us today, and thank you for everybody out there watching for sitting through that whole half an hour with us. Just to let you know, if you do need captions, or if you want to forward this video to someone who does need captions, our videos are also uploaded to our YouTube account after the show. So our production engineer will do that, and she will post a link in the comment section for you for those who do need captions. So with that said, next week I will be talking with our expungement law expert, attorney Todd Cagwin, to answer your questions about expungement. So for those who don't know, expungement is the clearing of your criminal records. So if you do have a question about expungement, you can either leave a comment down below for us or email us. or private message us. And remember to tune in next Tuesday at noon. Thank you so much and have a good rest of the week.